Corporations are legal persons, but they don't get all the rights of a natural person. In 1993, the High Court decided whether a corporation has the privilege against self-incrimination. In other words, is a corporation entitled to refuse to provide evidence if that evidence might incriminate the corporation in an offence? In this case, Caltex had approval to dump certain wastes in the Pacific Ocean. On 4 occasions in 1989 and 1990, government investigators found Caltex had unlawfully dumped some greases and oil into the ocean. Charges were brought. A demand was made under the New South Wales Clean Waters Act 1970 for Caltex to provide documents about its performance. Caltex refused because those documents may tend to incriminate it. The court considered whether this refusal was valid. A majority of 4-3 found that corporations do not have the privilege against self-incrimination. Even among those 4, there were 3 quite different judgments. In the leading judgment, Chief Justice Mason and Justice Toohey undertook a deep historical examination of the privilege and looked at the position in other common law countries. They found that the privilege against self-incrimination was a human right protecting the individual citizen from tyranny. Such a right did not extend to an artificial legal personality. They said, historically, the privilege developed to protect individual human persons from being compelled to testify on pain of excommunication or physical punishment to their own guilt. Second, the judges found that the privilege was intended to offset the much greater power that the state has compared to an individual. Corporations often have much greater resources and power than an individual, so they need less protection. They said, in general, a corporation is usually in a stronger position vis-a-vis the state than is an individual. The resources which companies possess and the advantages which they tend to enjoy are much greater than those possessed by natural persons. Finally, they found that the privilege protected individuals from generating new testimonial evidence. Corporations, by their nature, generate documents and must be accountable. They said, in the case of corporations, their books and documents constitute the best evidence of their business transactions and activities. It makes no sense at all to make the privilege available to a corporation in respect of these books and documents. It is now the law in Australia that corporations do not have the privilege against self-incrimination.